You've worked hard to accumulate for your retirement, and you want to plan ahead for your legacy to your children. Have you ever thought about how important it is to protect the inheritance that you leave to your children so that their spouse doesn't one day walk away with some of your assets if they ever get divorced? Let's look at a strategy to protect what you leave to your kids. Hello everybody, my name is Jeremy Curtis and welcome to the Lightstone Wealth Planning Solutions YouTube channel. I am a co-founder and advanced planning strategist here at Lightstone. I have a JD, a Master's in Financial Planning, and am a certified financial planning professional. Today in this video we'll be talking about advanced estate planning strategies and in particular how to protect inheritance that you leave to your children. So basically in this video we're going to look at how you can set up your estate to protect what you want your children to eventually receive so that those assets are protected for their benefit from creditors, predators, or divorcing spouses, from in-laws and outlaws. Basically, we want to make sure that we have things set up in a way that provides the benefits that you want to eventually leave down the road to your family members as part of your legacy. For a little bit of context here, we're going to use a hypothetical family as our case study. We'll call them the Lightstone family, Jim and Lynn Lightstone. Jim and Lynn have 3 children. We'll say that their oldest of their children is married. The other 2 are old minors, if you want to call it that. So they're still minors. They're at home, but they're not little kids anymore. They're in their teens. They have a little bit of concern about their oldest child. Their oldest child is married, and there's a little bit of strain and some cracks that they can see in the relationship there. But they're just kind of keeping an eye on that. They want things to work out well for their child. And they have current estate documents already in place that were put together years ago that were designed to distribute all of their property upon their passing to the children outright at age 25. So what that means is that if mom and dad were to pass away in a car accident tomorrow and everything is distributed out to the kids, as long as the kids are over age 25, they get the assets distributed to them directly. Basically, they get cash and property that they would directly own. Under the age of 25, those assets would be held in trust until the kids reach age 25, at which point it would be sort of handed over to them. So let's look at some details on this sort of case study. So the big objective here is, how do I protect a child's inheritance from the possibility of divorce in the future? So this is not a video about disliking one's in-laws. This is a video about protecting your children and loving your child and making sure that you take steps that are appropriate in case things don't turn out for them the way that you would hope that they would. Of course, divorce is a tragedy, but what we're hoping to talk about here is how can you build barriers or set things up within the bounds of legal capacity and ability to provide for the benefit of your children, just in case things don't turn out the way that you might hope. At Lightstone Wealth Planning Solutions, we focus our planning on several different areas. We basically have 5 areas. The central circle here on our graphic represents the financial plan, which is central to everything else that we do in planning. This is where we model out cash flows and assets, liabilities. This is where we model out goals and objectives people want to accomplish from a financial perspective. And we account for economic factors, things like what's going on in the economy and interest rates and inflation, and trying to model out best and worst case scenarios so that we can see, with a higher degree of confidence, what types of decisions today could have a positive impact financially for our clients in the future. But we also focus on these other 4 extremely important additional planning areas, advanced planning areas, in the areas of taxation, protection, estate, and investment. Today in particular, we're going to talk about some estate planning strategies for wealth transfer and estate planning, things that you can do to benefit your children at the time of your passing. But there is an overlap here with the top right quadrant of protection, where we talk about asset protection and setting things up in a way where you can create legal boundaries and set aside assets with special protections to sort of shield them from creditors and predators. But in this case, we're talking about shielding them from creditors, predators, etc., that may be trying to prey upon your children or upon the inheritance that you've worked hard to create for their benefit. So let's look at what this practically looks like and how this works. So as we mentioned, we have Jim and Lynn Lightstone, our hypothetical clients here. They come into Lightstone Wealth Planning Solutions and engage us to help them take care of a comprehensive planning arrangement. And one of the things that we want to look at is their current estate documents. If they have them, we kind of take a look at them to sort of try to help understand and decode what they do and how the distribution scheme works. And in this case, Jim and Lynn have wills where they leave everything to their spouse and then everything goes outright to the kids at the second death. So let's look at what this might actually look like. So Jim and Lynn have their property during their lifetimes. And upon the passing of one of them at the first death, we're going to choose Jim as the one passing away here to show what this would look like. But at the first death, Jim's estate would be separated from Lynn's additional personal and separate property. And their current documents are set up so that Jim leaves everything at his passing to Lynn. At the second death, this is what happens. Lynn's property then goes directly to the kids and is split evenly, 1/3 each to each of the children, as long as they're over age 25, to child 1, child 2, and child 3. So this is sometimes called an outright distribution, meaning that upon their passing, the assets will go directly to the kids, outright to them, or in other words, directly into their ownership. So the funds would be deposited into the kids' accounts in the kids' names. The funds or property, the real estate, would be moved over into the kids' names, etc. So this wouldn't happen until age 25, which means if they have two kids who are still minors, maybe let's say a 16-year-old and a 14-year-old, and then maybe their oldest child is in their young 20s and is recently married. Okay, so that's kind of the scenario that we're looking at here. So child number 1 is married, child 2 and child 3 are still at home and approaching young adulthood. If they're all under age 25 and mom and dad die in a car accident tomorrow, the assets would not be distributed out to them. They would be held in trust until the kids turn 25, at which point they would be turned over to the kids. So to further add some color to our scenario here, the oldest child is married, so Jim and Lynn have an in-law. So what could go wrong? What could happen here that might need to be accounted for today in their estate planning for the future? Well, the passage of time. Over time, sometimes things change and things can happen. There could be commingling of assets. So, even during Jim and Lynn's lifetime, but especially afterwards, when they pass away and property is distributed out, maybe mom and dad do pass away in a car accident. The child is under age 25, but now once the kids are all aged up, let's say they're all in their mid 30s or early 40s, and the marriage maybe looks a little bit rocky, and the assets have been distributed out, and they're being commingled. And what I mean by that is, let's say child number 1's property. If Lynn had $3 million at the time of her passing, and that distributes out $1 million to each of the kids, so $1 million to child 1, $1 million to child 2, and $1 million to child 3, all of whom are now over age 25, they would get those funds. And if child number 1 deposited those funds and those resources into a shared account, maybe a joint account with their spouse, from which they pay the bills and into which they deposit their earned income from their jobs, etc., over time it would be hard to legally distinguish the character of those funds as separate from the community or joint or marital funds that are part of their marriage of child 1 and the in-law. That's called commingling, when the funds sort of lose their character as separate. So what happens if conflict arises and, sadly, if a divorce ensues and child 1 divorces from the in-law and the in-law leaves? What could that look like? Well, in the case of divorce, property that's considered to be marital property or community property, or property that's considered to be part of their sort of joint marital estate, would be divided up according to equity and according to the rules and laws in your state. And what would happen is that child 1 may have to fork over some of the funds that were part of the inheritance that they originally received years ago from mom and dad, because the character of those funds is not separate and distinguishable under the law anymore. Now, there's more nuance and complexity to this. This is not a simple discussion or simple question, but we still want to talk about what some of the planning strategies are that you can engage in to help shield some of these assets potentially from this kind of event, thereby protecting the property that Jim and Lynn have worked hard to build up and that they want to leave as a legacy to their children from the possibility of something going south with a divorce and the possibility of creditors or financial predators seeking opportunity to take funds from their children's inheritance. So here's our proposal. We would say, look, you may want to at least have a discussion with your attorney and get their opinion and thoughts on the possibility of revising your estate plan during your lifetime, Jim and Lynn, to accomplish the following objectives. So in this case, maybe the wills would leave everything to the spouse and then to a testamentary lifetime trust for the kids rather than distributing outright to them at age 25. So how would that look? What would that look like here? Well, at the first death, it would look similar to what we saw before. Jim's estate would be separated from Lynn's property. Under their estate plan that they just revised, Jim still leaves everything to Lynn to provide for her. And there's lots of different variations of how this could be changed or modified for different scenarios. But in this case, we're just going to focus on the distribution at the second death. So upon Lynn's passing, Instead of leaving the funds outright to the kids at age 25, you leave 1/3 to each of the children in trust. So if Lynn had $3 million in her estate at the time of her passing, $1 million would go each to 3 different trusts. Trust number 1, trust number 2, and trust number 3. This trust would be called a testamentary trust if it was created by their last will and quote-unquote testament. So this testamentary trust, or this trust created by their will, would form a separate trust for each of the children, separating their assets. Now, there's different styles and ways this could be handled. Sometimes people have one trust with 3 accounts. There's lots of different ways this could be set up, and it depends on the facts and the situation and sort of even the preference and style of the different attorneys that you may be working with. But let's just focus on the big picture concept here. So these assets are now in trust for who? Well, for each of the children. So trust number 1 is for the benefit of child number 1, trust number 2 and trust number 3 likewise are for the benefit of child number 2 and child number 3. And so when child number 1 goes and gets married, now you've got an in-law in the family. Well, upon the passing of mom and dad, these assets that they left as inheritance, that $3 million that we're saying Lynn had at her death, turns into $1 million inside the trust for the benefit of child number 1. But with the passage of time, there's no commingling here. Why? Because these funds stay in trust accounts and in the name of the trust and are separate, sort of viewed as an inheritance, a separate property, and for the benefit of child number 1, and are not part of the marital estate. They're not mingled in with the funds that could be considered part of what would be divisible upon a divorce. So if there is conflict that arises later on, and if there is a divorce and the in-law takes off or there's a separation there, we can still have the benefit of there being no inheritance walking away with the in-law. In other words, the in-law could leave and other marital property would be divisible, but the inheritance that was left by Jim and Lynn for the benefit of child number 1 could still be protected. So how is this possible? How does this work? Well, these trusts would contain provisions that basically would block the claims of creditors against the assets in the trust. In other words, the trust would not be allowed under the provisions of the trust, under the rules of the trust, to distribute funds out for the benefit of the child if that was to satisfy a claim of a creditor. So if the in-law becomes a divorcing spouse and has a claim against the assets of the child, the trust would say, sorry, these are separate assets, these are separate property, these don't belong to the marriage or to the marital estate, and therefore cannot be divisible, and the child would be able to still have that benefit in the future after the divorce. Basically, the trusts form an asset protection barrier against creditors. Now, this is not the only strategy in the whole wide world. There's probably different ways this could be handled and different styles and perspectives from different attorneys. And so what we would really counsel our client to do in this case is to at least have a sit down with their attorney, discuss these issues, identify if there are real concerns here and what some of the different strategies and alternatives might be, and to make sure that they're comfortable with the way things are set up in their estate to be sure that it accomplishes their objectives and provides benefits that they want to see their children receive, while also protecting them against the possibility of future bad news and difficult life events they may have to face in the future. All right, so what are some takeaway lessons here? Well, there's a couple big lessons. One is that if you leave assets as an inheritance to your child and that child later goes through a divorce, whether or not the ex-in-law, the outlaws we'll call them now, walks away with some of your hard-earned money, could depend on how you left your inheritance to your child, whether that was left outright or protected in a lifetime trust for your children. If it was left outright, like we talked about before, that means it could go directly into the child's funds. It might be mingled and mixed with joint account assets that the marriage has, that the child and the in-law both have access to. It may be the funds they're paying their bills from. It may be the same funds that are being deposited into with earned income, and you sort of lose a distinct character of those assets over time, and the law has a difficult time necessarily dividing those assets as separate and distinct from the marital assets. That's the commingling thing we talked about. If you leave them protected in a lifetime trust for your child, you have a greater possibility of those funds being able to be distinguished as separate and for the benefit of the child, as opposed to being divisible upon divorce or divisible upon the claim of some other creditor. Without the trust, there is a risk of the inheritance being treated as commingled, belonging to the marriage and divisible upon divorce, as we said. And even in marriage, without a trust, there is more of a risk that a spouse could convince your child to use the funds for the in-law's next big idea or to frivolously spend it. So having the trust just provides an added layer of control and protection, an added layer of separation from the assets that you've left for the benefit of your child and to try to take care of them as part of your loving estate plan. So these are some of the things you need to think about, just some of the issues that need to be addressed as part of a comprehensive planning engagement, some of the wealth planning solutions that could be a benefit to you and to your family. We invite you to subscribe to our channel for more valuable strategies. Also, ask yourself, who do I know that this could help? And learn more about Lightstone and schedule a free 30-minute introductory call at www.lightstoneplanning.com.